This is Gary Davidson, and I head the real estate practice group at Castle Law. Oftentimes, we get phone calls after a closing saying that they believe that a buyer, uh, a seller, has not disclosed a property condition. In Illinois, it is the law that every party to a contract, when they're a seller, must complete what's called the real property disclosure report. And on that report, as a buyer, you're going to want to review that prior to fully executing the contract. And it's going to say if there are any material issues that are wrong with the property. The seller has to make that disclosure. Now, a buyer has 12 months from the date a contract was signed in the event a seller made a material misrepresentation on the real property disclosure report to bring a suit to sue saying that a seller materially misrepresented. Now, one of the biggest misconceptions is that this is somehow a warranty. And most often, what we find is whether a basement floods, or maybe there's a roof leak, or the toilet starts to leak, just because something happens does not mean that the seller is liable. The seller must have known that the problem occurred and failed to disclose it to you. So it's not enough simply that the basement leaked, but you have to prove that the seller actually knew that the basement leaked. So if you have questions about the real property disclosure, or after a closing, if you have problems, please contact us here at Castle Law. We have litigators in our litigation department that can assist you in analyzing whether you have a proper claim under the Real Property Disclosure Act.